Hello everyone, I am Mishra, an intern at LEXIS and Company. Today I will be discussing with you all about writ petitions, especially habeas corpus. So, writ petition is an order by a high court to a lower court or courts directing them to do something or stop them from doing something. Writ is a form of written command in the name of court. It directs you to act in a specific way, and it directs the court to act in a specific way. In the Indian legal system, you can file or draft a writ petition under Article 226 of the Indian Constitution in the High Court of in the High Court of the States, and under Article 32 of the Indian Constitution in the Supreme Court. So, Article 32 and Article 226 of the Indian Constitution elaborate on the process and draft and meaning of the writ petitions, or else at any point in the time you can consult an expert lawyer to draft a writ petition for you. You can also file a writ petition or a criminal civil writ petition in the High Court or the Supreme Court, depending on the case of the case or the matter of the case. In the case the High Court does not give a suitable judgment, you can then submit the petition of the writ in the Supreme Court of the India. So, it is important to know what is writ petition and what are its type defined under the Indian Constitution. How can you file the writ petition in the High Court or the Supreme Court of India? And it is also important to know how the judges work, how the judges order on the basis of the writ petitions. So, I would like to begin with a question: what is writ petition? What do you think about what consists of writ petition? How will you define a writ petition? How it is different from a case or a suit filed in the courts? I will give you the answer through this discussion. So, writ petition in India is the formal order of the court directing the authorities if there is a violation of the fundamental rights of the citizens by a government authority or a body. So you can file a writ petition in the Supreme Court, as I earlier said, under the Article 32 of the Indian Constitution. Whereas you can also file the writ petition in the High Court of different states under Article 226 of the Indian Constitution. You can also file writ petition in India for a civil or a criminal act. So, you can file a criminal writ petition when the cause of the action in relation to the criminal law, such as right of the accused, bail, etc. And you can file a civil writ petition when someone commits a civil wrong, such as wrongs in the field of IPR, in the field of taxes, etc. So, now I would like to come to the types of writ petitions. What are the types of writ petitions under the Indian Constitution? So, the Constitution of India gives the power to Supreme Court, where it issues writ petitions in India for the enforcement of any fundamental rights guaranteed under Article 32 of the Indian Constitution. The power to issue a writ petition in India is primarily a provision to the right of the constitutional remedies to every citizen, and this right acts as a guarantor of all other fundamental rights in India. Basically, there are 5 types of writ petition in Indian Constitution, which you can file either before the High Court or Supreme Court. And the name of the 5 petitions are habeas corpus, first one. Second one is the mandamus, then prohibition. Then fourth one is certiorari, and the last one is quo warranto. Now, as I said in the beginning of this video, that I will be discussing with you all about the writ petitions and especially habeas corpus. So now I would like to discuss with you all about habeas corpus. So the literal meaning of this term habeas corpus means you may have the body of. This body is important in the meaning of habeas corpus. You can file this type of writ petition when a person is illegally detained. Mind that. You can only file habeas corpus when a person has been illegally detained. Meaning, if the court finds out that the person is illegally detained, then it can order for the release of that person through the writ of habeas corpus. For example, when one person files writ petition of habeas corpus in nature, then the court orders the authority to produce the detained person before the court to examine whether he or she has been examined legally or illegally. And another example is that on conducting the examination, if the court finds out that the person has been illegally detained, then the court will surely and most probably will order for the release of that person. The scope of habeas corpus writ petition has been widened by the Supreme Court in various judgments and also in the recent time. Now you can also file the writ of habeas corpus for violation of fundamental rights of the prisoners. Like if the fundamental rights of the prisoners are violated, then you can file the writ of habeas corpus. For example, in case of Sunil Batra versus Delhi administration, this writ of habeas corpus was filed in matter of the violation of the fundamental rights of the prisoners. The Supreme Court also explained the meaning of the writ petition of habeas corpus very well in the case of P.S. Sadasiv Swami versus State of Tamil Nadu. Now I will not go into the detail of that case, that what was the fact of this case, what the court has ordered in that case. That is the matter of another thing. Like we will discuss that matter some other time in some other video. But now in the series of this discussion of habeas corpus, as the discussed till now, I would like to sum up the features of writ of habeas corpus, and they are that court has the authority to ask questions regarding the causes of detention of such persons who has been illegally detained if the writ of habeas corpus has been brought before the court, and the court can issue a summon for the production of the detained person in the court. So if it is concluded that the detention of the person is illegal, the court will surely order for the release of that person, and one can file the writ of petition, writ of habeas corpus in any of the courts, be it High Court or the Supreme Court. Mind that I have said only that you can file the writ of habeas corpus either in Supreme Court or in the High Courts, and it is necessary to remember that you cannot go with the writ of habeas corpus in the session courts or in the district level courts. So you can only file this petition either in the High Court or the Supreme Court. Now also one can issue it under the various circumstances, and I would like to mention those circumstances that under which circumstances this writ of habeas corpus can also be produced other than the illegal detention of a person. So if the person has been detained and has not been produced before the magistrate within the 24 hours of the detention, within the 24 hours of the arrest, so this writ of habeas corpus can be filed in this situation, in this circumstance. The another circumstance is that the person has been arrested without any violation of law done by that person. So if a person has been arrested, if without any violation of law, like he has not violated any law, he has not committed any wrong, still he has been arrested, then the writ of habeas corpus can be filed in the court, be it a High Court or in the Supreme Court as per the circumstances exist. So, and another circumstance is that the arrest has been made for an unconstitutional law, that is a law against the provision of the Indian Constitution. One of the other circumstances is that detention is done with the malafide intent or with the intent to harm the persons or the person who has been arrested. So if a person has been arrested by the authority with the intention of harming him or with the malafide intent, then the writ of habeas corpus can be brought in favor of that person. So I would like to ask you a question, like it is easy to file a case in the civil court or in the lower courts, but when it comes to High Court or Supreme Court, the procedure and the processes gets a bit complicated. So what do you think, that who can file a writ of habeas corpus, and who is capable of filing, and who has the power of filing writ of habeas corpus in the Supreme Court or in the High Court? So I would like to answer this question of yours. Not yours, it's my question. It is my question which I asked to you. So I would like to answer this, that generally the person who has been illegally detained, as in the illegally detainee files the writ of habeas corpus. So the person who has been illegally detained that he can file or she can file the writ of habeas corpus. But to begin with the writ process for filing a petition of habeas corpus, one can file it and issue it against any public authority or any particular individual. So sometimes it has also been seen, not sometimes but many times it has been seen that the detainee cannot file the writ of habeas corpus. So in certain cases the court may allow other people to file a writ of habeas corpus on behalf of the detained person who is their friend or relative. So this was all from my side about the writ of habeas corpus, and in short the detail of summarized detail of petitions existing in the under the Indian Constitution. So this is all from my side. Thank you.